I'm Ashley Matthews, a Senior Associate in the Employment Team at Thompson, Snell & Passmore. In today's video, I'm joined by Nick Hobden, Partner and Head of Employment, who is with me to talk about employee dishonesty, and in particular, stealing from employers. This is one that unfortunately crops up more often than many organisations would like. It's a real challenge because dishonesty strikes at the heart of the employment relationship, trust and confidence. And when that trust is broken, employers have to tread carefully. It's about balancing a firm, fair response with making sure the process stacks up legally. So what we'll do in this chat is unpick some of the practical and legal issues that come up when you're dealing with allegations of theft or dishonesty at work. Let's start with the basics. So what do we mean by employee dishonesty in this context?
So actually, employee dishonesty is where an employee is dishonest, and we are referring here to what they do when they commit acts which breach the fundamental relationship of trust and confidence which exists between an employer and an employee. And that's what actually keeps the employment relationship going. That's what sustains it. If you don't have a relationship of trust and confidence between both sides, then an employment relationship can't continue. We're talking about acts like theft of money or stock or equipment. It can also include things like falsifying timesheets, fiddling expenses, supplying goods or services at a discount to friends or family, and can even extend to misuse of confidential information passed to a competitor. So all of that is in the umbrella of dishonesty. The key theme here is that the employee is doing it for their personal benefit or gain.
So how should an employer respond if they suspect their employee is stealing?
Well, actually, the golden rule is not to jump to conclusions. They need to investigate properly, and that means conducting an evidence-gathering exercise, whether that's through an audit trail or examining CCTV records if CCTV is working in the premises. That includes conducting a thorough review of the processes by which stock has gone missing, for example, and the ACAS Code of Practice applies here. That sets out the process that should be used in cases of dishonesty, including employee theft. And so what that means is the ACAS Code of Practice, which is taken into account by all employment tribunals in cases of a dismissal for misconduct, means that the investigation has to be thorough, and usually that means an investigation meeting where the employee is given an opportunity to explain themselves and answer questions. And that also means making sure that there's no knee-jerk reaction, so the instinct to dismiss on the spot is not the right thing to do, because that's likely to end up in an employment tribunal claim for unfair dismissal. It's all about the investigation, and there has to be a reasonable suspicion of guilt arising from that investigation.
So is theft always gross misconduct, and will it automatically justify dismissal without notice?
Theft usually does amount to gross misconduct, and many cases will mean that where a gross misconduct offence has been committed, like theft or other forms of dishonesty, then a summary dismissal without notice is justified. However, context matters, and what that means is that employers will have to ask whether the theft was deliberate, how serious it was, what's the value involved, has the employee shown any remorse, what are they offering to put right in terms of perhaps reimbursing the cost of the goods stolen. Employers have to look at the bigger picture, and that also includes looking at the individual's personnel HR record, their employment history, their disciplinary history, to see whether they have committed a similar offence before. So the decision to dismiss for gross misconduct has always got to be based upon a reasonable suspicion formed as a result of a reasonable investigation, and that means a thorough investigation and taking into account all the factors.
Are there legal risks for employers when dismissing employees for dishonesty?
Yes, there are. I mean, the most obvious risk is a risk of an unfair dismissal claim if the process wasn't fair. So, for example, if the investigation wasn't thorough, certain witnesses weren't interviewed, for example, or if the dismissal was outside what is known as the band of reasonable responses to the conduct involved. So if the allegations were unfounded, if something wasn't investigated as it should have been, or certain evidence hadn't been taken into account, then it's quite possible that an employment tribunal will find that there was a defect in procedure resulting in the employee being dismissed, and they are quite entitled to therefore find that the employee has been unfairly dismissed. And there's also a risk that, for example, if someone is falsely accused of theft or dishonesty and they're given a written warning, perhaps a final written warning, they might decide to resign in response to that warning, citing a breach of their implied term of mutual trust and confidence, which they will say the employer has breached, and entitling them to resign in order to claim constructive unfair dismissal. And in some cases, where there's been a lack of consistency, for example, someone of one gender has perhaps been given a warning, but someone of another gender has been dismissed, then there's an inconsistency of approach, and that might lead to a discrimination claim from the employee who's been dismissed.
Do you have any practical tips for employers, both on how to prevent dishonesty from happening, but also how to deal with it effectively when it does happen?
Yeah, so there's a few key points. The main one for me is your policies. So employers should have decent, up-to-date disciplinary and grievance policies. All too often we see those sorts of policies that don't contain enough information about employee dishonesty, making it a gross misconduct offence. And so the more that an employer can put into a policy to differentiate between gross misconduct, for example, and serious misconduct, and the various shades, the better it is, because everybody is then well aware of what constitutes gross misconduct and what constitutes serious misconduct, for example. And it sends a message out to employees that they can potentially face dismissal if they commit an act of gross misconduct. Far better that that sort of information is contained in a comprehensive policy. Other things to think about are carrying out pre-employment checks before hiring staff, because they potentially could have committed similar offences at a previous employment. Also foster a culture of transparency and openness where employees are not afraid to come forward and tip off the employer about things that they're concerned about. Perhaps colleagues of theirs are falsifying their timesheets or making bogus claims or passing on discounts to friends and family when they shouldn't be doing so. And employers can have a whistleblowing policy that will cover those sorts of confidential reporting of incidents, which means that the person who tips off the employer can actually remain anonymous, and the information they pass the employer is treated in confidence and confidentiality, and potentially the employee who is about the tip off, the employee who's suspected of committing theft or dishonesty can therefore be suspended pending an investigation. And then finally, I would say that employers shouldn't rush into dismissal straight away. Even if they think the employee is guilty, they should conduct a fair investigation, fair and thorough investigation, in order to build a case and gather the evidence for a disciplinary hearing. Because if they do all of that work in the first place, then they will remove the potential risk of an unfair dismissal if they end up by dismissing. So those are my tips.
Thank you, Nick. So to sum up, dishonesty and theft at work can feel like a clear-cut reason to dismiss. And in many cases it will be. But employers still need to slow down, follow a fair process, and make sure the sanction is reasonable. No one wants to be on the receiving end of an unfair dismissal claim or accused of acting hastily or unfairly. And just as important as responding well is prevention. So clear policies, good culture, and sensible checks can make an enormous difference. If you suspect that one of your employees is stealing from your business or is being dishonest and you need some advice from our team, then please do not hesitate to reach out to us.